Hello, everybody. Welcome to the first DATAMITE webinar related to legal framework for data sharing, ensuring legal and ethical compliance. So welcome to this meeting, Polina Petrova from Law and Internet Foundation and Margit Hofer from Center for Social Innovation.
Hello, everyone. Once again, on behalf of the Law and Internet Foundation, as well as the Center for Social Innovation, my colleague Margit Hofer is stepping in at a later stage. We're welcoming you to our webinar concerning the legal framework for data sharing, so crucial, evolving and becoming more and more relevant, and more particularly regarding how to ensure legal and ethical compliance. Thank you, Antonis. Let's proceed. So very briefly, a high-level view of the topics that we're delving into today. So we are, of course, first of all, opening the data sharing topic, talking about its relevance, why it is so relevant and important, why it is so crucial in the context of the 21st century economy. Then we are also going to very briefly touch upon the different stakeholders within the data sharing scenarios. This is very important, in order to consequently be able to grasp the general essence of the regulatory and the ethical framework, of course. We are then going to wrap up and present a very interesting and important table concerning the coherence of this legal framework, what it means. We are going to very briefly compare the essence of each act, so that when you visualize it within the table, you are able to grasp upon the similarities and then also the differences, and how how each act complement the other, and so on and so forth. We're also going, of course, to discuss the dual nature of the legislation. And what we mean here is actually, of course, on the one hand, the regulatory framework is usually perceived as a barrier, as a challenge, so in other words, as a limiting requirement. However, we are also going to look at the other side of the coin, so to speak, and see its fostering nature. We are then also going to very briefly go through the good practices in terms of the ethical dimensions, which my colleague Margit is going to complement. And then we're also going to conclude with the topic of data spaces, which is also becoming more and more relevant nowadays, and how actually data spaces are able to balance these evolving regulatory frameworks. Please, Antonis. Data is the 21st century's oil, says Siemens CEO Joe Kaeser. And actually, not only him. Many times, more and more often, we hear this statement. And I couldn't agree more than this. Why it is valid, and where it is evident that it is so valid. So first of all, the increasing importance, which is underscored by online platforms and IoT devices, Internet of Things devices. Then we also have the pivotal role for the training of AI algorithms, which in turn improve decision-making and operational efficiency. Thirdly, there is the enhanced customer experience, which lowers production costs and also leads to gained competitive edge. All in all, effective data sharing is a strategic necessity vital for driving innovation and economic advancement. Next slide, please. Of course, as usual, as usual, there is another side. So challenges to effective data sharing exist, unfortunately. And these are usually related to interoperability requirements, to regulatory barriers, to security concerns. The lack of robust data market creates incentive problems, as firms often struggle to assess the value of their data, which usually leads to either open access without compensation or a reluctance to share at all. Developing efficient data sharing mechanisms, of which regulatory compliance is an indispensable part, is thus crucial for realizing the full potential of data and for fostering innovation. And exactly designed to tackle these existing issues, the EU has, of course, introduced the new legal framework, which we are discussing today. And of course, the common European data spaces are quite intertwined with all these topics we're touching upon. So let's begin with more details then concerning the stakeholders. Next slide, please, Antonis. Types of data and stakeholders in data sharing. This is a very important slide as an introduction to the more detailed framework. So as we know, data has this non-rivalrous nature. What this means? It means that data could be utilized by multiple entities simultaneously for various purposes, oftentimes generating new data. And exactly this dynamic nature, this multifunctional, multi-layeredness, differentiates data from most natural resources. And it also underscores the necessity of broad access and incentivized sharing. Of course, boundaries are blurring in terms of categorizing data. What we mean here, traditional distinctions between personal, non-personal, private, and public data are increasingly overlapping. And in fact, the highest value from data oftentimes arises exactly from combining data sets. So data sets which come from diverse sources and which enable the development of data-oriented products and services. Why we mention this fluidity here is because it highlights the evolving nature of data and thus the need for adaptable regulatory framework. From a more practical view, data integration across sectors can significantly enhance public services, as we witness, and operational efficiency, as already mentioned. Hence, improved data sharing could revolutionize areas like, let's say, traffic management, urban planning, public health, leading to more effective and responsive service delivery. I'm not certain how familiar all of you are with the different stakeholder roles within the data sharing process, but on a very high level note, there are usually 4 main roles. On the one hand, we differentiate the business-to-business data exchange, obviously between commercial entities. On the other, we have the business to government, which concerns the provision of data from private sector entities to government bodies. Well, this is usually for the reasons of regulatory compliance, public service delivery, and policy formulation. Then we also have the government to government, which concerns the data sharing between different governmental bodies, which facilitates internal coordination, and of course, eventually decision making. And then finally, we have the government to business, which regards the dissemination of public sector data to private entities. And then this, of course, is aimed at driving, again, innovation, fostering transparency, and supporting economic growth at large. So let's proceed further. So having done extensive research within DATAMITE and supporting pilots, we are currently developing our second robust deliverable 4.6, which is going to be public, so stay tuned. We are going to share it publicly with all of you. And we are touching upon the very core regulatory framework, which includes the Data Act, the Digital Markets Act, Digital Services Act, Open Data Directive, the Governance Act, of course, the GDPR. I'm sure everyone, all of you is familiar with it, but then also the free flow of non-personal data. Of course, this is actually not the full exhaustive list. We are now concentrating on these main pillars of the regulatory framework because they are the very core of the data sharing per se. But then within the deliverable, we are also going to cover the AI Act, the newly enacted Data Interoperable Act, and then we're also going to discuss in details the sectoral regulations. So this includes the data spaces, also on the very domain level, energy and electricity, payment services directive, and so on and so forth. Of course, we do not have time today to cover all of them in detail, but this is for you just to have this very high-level overview and to know which topics we're dealing with. Yes. Very briefly, the Digital Services Act, of course, with you see the acronyms provided in brackets. Well, this act presents obligations of intermediary service providers. By the way, let me clarify once again because, before we proceed. The idea for you is to know today, to know and to get acquainted with the existing sources and where you're able to find which topics. So the existing framework and which topics they're dealing with. What answers to which questions they're providing. And then we're going to go into details later. So pretty much the DCA Act ensures the following: an easy way to report illegal content, goods or services, stronger protections for people targeted by online harassment and bullying, transparency around advertisements, bans on certain types of targeted ads, of course, easy to use, free of charge complaint mechanisms for if an online platform takes our content down, simplified terms and conditions. Then the stakeholders are the data user, the data holder, and the data recipient. Of course, probably by the wording, you're already able to grasp what these roles concern. But of course, for your convenience, they have been explained on the slide. Of course, you're going to receive a copy of all the materials after the webinar. The very main principles that this act clarifies are the following. The obligations of data holders within the meaning of the IoT, B2C and B2B data sharing, the obligations of the same concerning mandatory B2B data sharing. Of course, this act establishes the mandatory nature of B2B data sharing. Then, of course, the obligations of data holders concerning the business to government data sharing. And on the other hand, the obligations for data providers on switching between data processing services, and also their obligations within the meaning of the interoperability requirements. The Digital Markets Act. The Data Act aims to standardize data access and data sharing across various sectors. Very briefly, the type of data that this framework deals with is private data and metadata. This means product and related service data, so pretty much data which is derived data and information resulting from further analysis, processing or transformation of the primary data, and which is actually not covered by the DEA. The pro-sharing objective is private data sharing, and the main tools for achieving this objective has been achieved through setting obligations on sharing data in terms of B2C, B2B, B2G, and of course, a very minor clarification, because I presume that you have less context within the business to government framework. So this usually concerns scenarios during public emergencies within the current context, I mean. Then also the Data Act provides a general framework for data access and sharing. Again, the stakeholders are the data user, the data holder, the data recipient. The user within the meaning of purchaser, renter, or lessee of a data-generating product, or the recipient of a data-generating service. And then the holder typically is the party with the factual control over the data. For example, let's say a tablet manufacturer. And then the data recipient, of course, is the party that in a business context and without being the user received data from the data holder. We see here the main principles and obligations outlined. Again, they concern the mandatory aspect of B2B data sharing, also within the meaning of IoT, the business to government, and the switching. The Open Data Directive. You see how many sources and how many obligations there are, but we're going to see eventually that on the one hand, although perceived as countless and numerous requirements and barriers and challenges, they're in fact contributing to the effective data sharing. So pay attention and follow us, because apart from facing hefty fines if you're not compliant, you're also precluding the effective data sharing. So it is very important that you follow through all these important aspects. Okay. Open Data Directive. This piece of legislation promotes the transparency and access to public sector data. It means that it promotes data sharing between public authorities and the private sector. Of course, the main data being addressed is public data, and the main pro-sharing objective is the public data reuse, which follows the very famous principle established by the European Commission in this sense, as open as possible. I'm certain that you have already heard of it. Then the main tools which are being used to achieve these objectives is setting the obligation to public sector bodies to offer public data for reuse. So you see that in this context, we touch upon the government to business data sharing aspect. Of course, the stakeholders are the public sector bodies, and then on the other hand, the undertakings. Why this piece of legislation is important? For two main reasons. On the one hand, it promotes while promoting, as we already mentioned, the reuse of public sector information, It particularly requires public bodies to make their documents available in a certain standardized format, machine-readable, accessible, complete with metadata, and emphasizing the principles of openness and accessibility while ensuring the dynamic and real-time data is immediately available for reuse. So I'm certain that you already managed to grasp the importance of this directive, because without the existence of provisions like this, the entire process is compromised. Then on the other hand, it also introduces the concept of high-value data sets. I'm sure that you're familiar with these types of data sets, which have been further developed by the respective implementing regulation. And the directive itself categorizes the high-value data sets in six main directions: the geospatial, the Earth observation and environment, the meteorological, the statistics, companies and company ownership, and mobility. Please, Antonis. So, the Data Governance Act. You see, many of these regulations have very similar names. So I think that providing the main type of data, the pro-sharing objective, the main tools and principles, like you see them visualized on the slides, is very important, because I can imagine for a non-legal professional, it is very easy to get lost in all these intertwined topics. So in this case, the Data Governance Act provides a governance framework for encouraging both government to business and business to business data sharing. And it actually establishes the role of data intermediaries. The type of data which is of central concern to this piece of legislation is the public data. The pro-sharing objective, as you may already guess, is governance of data sharing, including establishing trusted data intermediaries, very important, also in the context of data spaces, thus ensuring public data reuse. Or again, we go back to the as open as possible. It is very similar in a way to the previous act. We are going to see in one of the next slides, we have done this comparison for you. So to be able to see where exactly is the line of the similarities, and then where is where the difference lies in terms of obligations. Main tools, could we go back? Yes, thank you. The stakeholders, obviously public sector bodies, data intermediation service providers, altruism organizations, very important. This act also touches upon the topic of data altruism. And then the main principles concern the public sector bodies, the reusers, of course, the intermediaries. Yes, please, Antonis, and altruism organization. Yes, so here is the slide I just mentioned, the comparison between the Data Act and the Data Governance Act. So in terms of similarities, as we saw, they both enhance data sharing, in that both acts promotes the utilization and sharing of data, they both actually facilitate the easier access to and sharing of data. And then on the other hand, they both foster trust and compliance, in that both acts include provisions for the insurance of data handling compliance with EU standards regarding data protection, privacy, security, complementing the GDPR. They actually complement the GDPR. But then There are differences, obviously, because these are two different sources. So, albeit complementary in their nature, they address different aspects of the data lifecycle. On the one hand, concerning scope and focus, the DGA focuses on the governance of data sharing across sectors, including public sector data, and establishes a framework for data intermediation services to operate in a trustworthy manner. On the other hand, the Data Act primarily targets the economic aspects of data generated by Internet of Things devices and services, addressing issues like who can use and access different types of data and under what conditions. Then concerning the regulatory emphasis, the DGA emphasizes the establishment of data intermediaries that are neutral and trusted, facilitating data sharing and reuse, particularly for public sector data. The other act, on the other hand, deals more with the rights related to data generated by products and services, as we saw, including business-to-business and business-to-consumer relations, thereby focusing on fairness in the entire digital ecosystem. Please, Antonis. Of course, very briefly, and certainly a very central role, as usual, within the digital realm is the GDPR. We are not going to go into details, of course, because we may have one separate meeting for the GDPR only. We are dealing with it in the deliverable again. We are going to get access to it. But on a very high level note, the GDPR has a very dual objective, a very dual role, because it aims at protecting personal data while enabling data flow, data portability. And in aiming to achieve and maintain this core objective, it has set few core principles concerning the lawfulness, fairness, and transparency, the purpose limitation, the data minimization, accuracy, storage limitation, confidentiality, accountability. But also it has established the notion of lawful processing of data and the scenarios and the conditions under which such lawful processing is established. And then on the contrary, of course, when it is not. Of course, it also deals with special categories of sensitive data, data related to children and so forth. You can eventually go into details once we share the materials with you. Of course, we also have the free flow of non-personal data, which, as you may grasp from the title, aims at removing obstacles to the free movement of non-personal data. The very main tool for achieving this is the ban on data localization measures. It deals, the Act deals with the obligations on handling mixed data sets by stating that whenever both personal and non-personal data are present in a data set, which, by the way, is very often the case, the regulation on the free flow of non-personal data applies to the non-personal data, whilst the GDPR continues to apply with regard to the personal data, even when they are inextricably linked, which is, again, very often the case. And very important as well, where technological developments have made it possible to transform anonymized data into personal data, those data must be treated as personal data. and the GDPR should apply accordingly. Of course, it is not an easy task to, very often for non-legal professionals, it is not easy to differentiate between the two. I can imagine for non-legal professionals, which is where our role as legal professionals is to step in. This piece of act also regulates the obligation on the porting of non-personal data. More particularly, the free movement of non-personal data across borders. As we mentioned, a prohibition on data localization is in force, and then every organization should be able to store and process data anywhere in the EU. The availability of data for regulatory control. Public authorities will retain access to data even when it is located in another EU country or when it is stored or processed in the cloud. Also, concerning easier switching between cloud service providers for professional users, the Commission has stated has started facilitating self-regulation in this area, encouraging providers to develop codes of conduct regarding the conditions under which users can move data between cloud service providers and back into their own IT environment. So we are following on to this. And in order to receive more insights onto the cloud aspects. Actually, even though this act does not directly address open source and multi-domain software, and this is, by the way, not an official part of the act itself, but it is more on an analytical level, from an analytical point of view. So even though this act does not directly address open source and multi-domain software by allowing the free flow of non-personal data, the regulation can support the availability and accessibility of data that can be used for these purposes. The document also indirectly addresses the interaction with databases and systems by encouraging the free flow of non-personal data, by aiming at removing unnecessary restriction on where data is stored and processed, thereby ensuring that businesses and organizations can freely transfer non-personal data across borders. Thank you, Antonis. So here is the slide that I promised in the very beginning. I think that it is a very good idea to have this table at hand, both for us legal professionals, but even more importantly for you, when you're wondering what to find where. So on the left side, you see the titles of the most core and relevant regulations. And then in the other part of the table, within 3 pillars, you are able to see in a very summarized way the type of data that the regulation deals with, the pro-sharing objective, and how, through which tools and obligations, this regulation achieves the set objectives. I'm not going to go and cover the content again, because as you see, this is pretty much the very essence of what we already discussed. Thank you, Antonis. Then we are also again going to touch upon in more detail the dual limiting and fostering nature of some laws, more particularly intellectual property, competition, and personal data protection laws, against the context of service data sharing. Why we have decided to touch upon this? It is very important because usually we, as I already said in the beginning, we are used to hearing how legislation is limiting and challenging and posing barriers, Whilst, in fact, although, of course, to a certain degree, it's true because you have to meet obligations, but then on the other hand, if you look on a more high level, these requirements are there to actually foster data sharing. So, for example, if we speak about intellectual property, of course, it is true that safeguarding proprietary information and incentivizing innovation through exclusivity, which is the very essence of IP, may be restrictive to the free flow of data, as IP laws prioritize the protection of this type of property over the sharing of data. And in addition, the lack of copyright and patent protections is limiting to the ability to enforce and strengthen the position of data holders, thus constituting an obstacle to data sharing. It's true. But yet, on the other hand, IP laws can facilitate data sharing through mechanisms such as licensing agreements, which allow controlled data sharing while ensuring the preservation of IP rights. Furthermore, providing residual protection that can support data sharing initiatives, IP protection may, on certain instances, extend to trade secrets, to copyright, as well as to sui generis rights on databases. This is a Latin term, but in the context of the sentence, you see that this basically means that the protection of databases. Then on the other hand, if we discuss competition law, which is perceived as another serious and effective barrier to data sharing, because being designed to prevent anti-competitive practices, competition law can inadvertently hinder data sharing initiatives, more particularly the application of the cited article of the Treaty on the Functioning of the EU, which addresses anti-competitive agreements, may lead to complications in data sharing between firms, as well as potential violations of the secondly cited article of the TFEU, which addresses the abuse of market dominance, may also trigger restrictions on data sharing, as for example, a dominant company may face antitrust scrutiny if it pressures its business customers or individual consumers to share their data. It's true. However, at the same time, competition law can also be a catalysator for data sharing by ensuring that market practices do not suppress collaborative efforts. For example, the initially cited TFEU article, more particularly paragraph 3, provides potential exemptions for certain data pooling, standardization, or research and development agreements. In addition, merger scrutiny under competition law can prevent excessive data concentration, thereby encouraging a more balanced and competitive data sharing environment. And then concerning data protection, of course, this is usually the most debated aspect of the regulatory framework. Prioritizing the privacy and security of individuals' data protection laws ensure that data subjects maintain control over their information, as well as that the same is also able to impose significant restriction on how the data is being shared and utilized, thus affecting collaborative data sharing initiatives. Of course, it's true, but then you have to also look at the other side of this aspect, that secure data sharing mechanisms and frameworks based on robust privacy safeguards and data sharing protocols can actually facilitate data sharing and certainly increase trust in data, which is actually one of the central current goals on a more high-level policy development stand. Good practices, ethical dimensions. very often undermined because having this differentiation between regulation and ethical principles usually channel people into perceiving ethical principles as more or less subordinate because they're not so enforceable in the sense of the regulatory sources. However, I would say that they are equally important, and they are. Therefore, do not be misled by the naming, the titles. Just perceive all requirements, guidelines of an integrated whole, because they're very, very intertwined, pretty much related. And to be honest, oftentimes, if we look back at history, ethical requirements are the predecessors, and they define the evolving regulatory framework. This is very valid also in the context of the AI Act. So please pay equal attention. I'm going to very briefly clarify the context of the ethical dimensions. And then my colleague Margaret is going to step in and complement me with the next slide. So, first of all, the data ethics constitutes a framework for ensuring that data is handled in ways that are not only legally compliant, but also fair, respectful, and beneficial to individuals and society at large. And we have outlined some of the very core principles in that regard. So we have decided to make this distinction. As you see, on the one hand, we have the context of the Horizon Europe projects on a more high-level note. I think it's important to mention this briefly. Usually, ethics within the context of Horizon Europe projects concerns human participation, which always require robust data monitoring and documentation preparation for, let's say, during validation and testing, integration events, and so on. You grasp the idea. Then also we have this aspect within the meaning of the dissemination and communication, which is also a central pillar and process within these projects. Why? Because, again, it involves dealing with data, with personal data. Then we have the piloting and demonstration events themselves, which require a very serious monitoring in order to meet the European Commission obligations, in order for the entire project to meet its obligations. And then, of course, we have the technical solutions aspect, which is the central aspect of our webinar. So these are related to the actual requirements, to the data sets, to how you treat data, to how you store data, to how you share data. The underlying principles are pretty much related to the privacy by design and by default doctrine. You can understand from the title, from the wording, that these principles have to be embedded within the system already in advance, proactively, from the very beginning, and in such a way so that they ensure the by default compliance. They are related to privacy, to requiring informed consent, to transparency, accountability, fairness and non-discrimination, data minimization, purpose limitation, security, right to access and correction. all of which are going to be addressed very briefly by Margit in a second. As you see, these are very key words which probably take you back to the legislative part, and it's true because, as I mentioned, and you see now a very good example, that they're not really separate. They're actually, in fact, quite intertwined. They complement each other and they address the same topics, which is why I mentioned that both regulations and ethics principles are very important. They are an integrated part. Please, Antonis. And Margit.
Yeah, thank you, Polina, for doing this introduction. I think it's a very important part that you aligned to us. However, what we wanted to do also to explain a little bit what are these 9 cornerstones, very much tackled to practice. So what is privacy? It's the first cornerstone of these good practices. What do we mean when we talk about privacy? Privacy, in the sense connected with data sharing, is really this individual's right to control how that data information is, how it is collected, how it is stored, how it is used, and also with whom it's being shared. So this is a very important part that you are aware that you need to make sure that this privacy is protected. Why? Because if it's compromised, the individuals can face serious issues like discrimination, emotional stress, or social stigmata, but obviously also identity theft. So be aware that the organizations, that they are in the responsibility to protect these personal information very well by using security systems, encryption, as well as clearly define also these data access policies. But privacy also means that that you're respecting the privacy in the sense that only collect really what is really necessary. So don't collect additional information you feel might be useful, but only collect really what's necessary. But also make sure, and this is a very important point, ensure that the individuals understand the consent to how their data is handled. This is usually this is collected by the informed consent. I think all of you have already agreed to some way of informed consent. But what is important on the second cornerstone is really that you make clear what data is being collected, why it's being collected, and also how it is being used. So these are the three items you have to clarify. Obviously, these consents, they must be obtained before any data collection tasks are being performed. They must be given freely. So and also all individuals, they do have the right to withdraw these consent at any time. So this is something that you need to be aware. Okay. What is also very important is that you are very transparent. Why is that important for you? Because being transparent means also that you foster the trust, and that it also enables the user to hold your organization as accountable. So this is a very important point. What does it mean to be transparent? Basically, it refers to being open and honest about the data practices. So what I mentioned also before, how it is used, how it's being collected, but also how it's being processed, how it's stored, and how it's being shared. It's also important that you provide understandable explanations of the algorithms used in the decision-making system. So this is also something that an individual should know, once it gives the agreement that the privacy data is being stored. Be aware that you're also accountable for this data. So accountability means that individuals and organizations must take responsibility for how they manage and use the data. In case of any harm, so unethical practices like data breach or discrimination, misuse of data, you must take corrective measures. Yeah. How can you do this in practice? A lot of companies, they're installing data ethic committees or boards, external audits or external experts that are engaged to make sure that this accountability is secured. Yeah. Another cornerstone in terms of ethical use is the fairness and non-discrimination. What is it when we talk about fairness? Fairness is all about ensuring that the data and algorithms do not lead to unjust or discriminatory outcomes. Really do regularly test and correct the system. This is something that's very often overlooked, that you also regularly you need to check on these systems. Talking about fairness and non-discrimination, you also need to address bias. Bias is sure that automated systems do not reinforce inequalities, like gender as an example, or exclude vulnerable population. In terms of bias refers really to the systematic distortions in data collection, processing, or algorithmic decisions. Meaning, as an example, that you would only collect data from males or from a very specific user groups. Yeah. So this bias can stem from unrepresentative data sets or hidden societal prejudices. So please do make sure that you have an ongoing monitoring system, that you use device data sets, including design practices, but also involve actively affected stakeholder groups. This is something that can prevent you from having a bias in your data set. The sixth cornerstone that Polina was referring to is the data minimization. As mentioned before, only collect data that is necessary for achieving the given purpose. So this is an important part of ethical usage of data. Also, ensure that you delete data as long as it's no longer necessary. So once the data is no longer necessary, make sure that you also delete these data. Okay. Also try to reduce storage risks and protect the user identities. This is something that's quite technical part usually, but this belongs also to the data minimization. As mentioned beforehand, it's only collect data that is needed, but also make sure that the data that you collected, that should only be used for the reasons specified at the time of your collection. So what's been written in your consent file, you usually have the purpose there, and you are only allowed to use the data for that specific purpose. Might be sometimes very tempting to use data for another purpose. However, this is not an ethical handling of data. Only use it for the reason that you specified, okay? Obviously, security is something that is most important when we talk about data sharing and data handling. So make sure that you implement measures to make your data safe, safeguarding data from the loss, unauthorized access, or attacks that might lead to misuse. What would be a good idea, or what usually is a very good idea, is also to train the staff in cybersecurity for best practices. So this is something that is quite important when we talk about the data handling. And finally, one thing that you should always consider when you collect data, be aware that individuals have the right to access the personal data and change them. Yeah. So anytime individuals can go back to the data, they can withdraw, and they have access. They should have always access, and they also are able to correct. Explain also how your data is used, and request also corrections in case the data are no longer up to date. So in case the data are very old, you might go back to the individual user and ask them for corrections.
Sorry, Margaret, because time is, let's say, advancing very fast, and we are in an
that
hour.
was the last point.
If you can, yeah, if you can summarize, it would be very nice, so we can give few minutes
Thank
for
you.
questions. And thank you for.
Thank you, both of you. Very briefly, mentioning data spaces, and we're of course going to develop the topic further and into details within our publicly available deliverable. Data spaces as the possible place to balance the regulatory frameworks. Why there is such need for balance? Of course, because there are gaps, there are places for further interpretation, for further codes of conduct and guidelines. Of course, multi-layers in terms of sectorial aspects and so on and so forth. So, to overcome technical privacy and security barriers currently hindering data sharing in specific sectors, EU is actively supporting the creation of common European data spaces in strategic sectors, with each data space aiming at creating a single market for data. As for example, in the healthcare, which is actually advancing pretty rapidly, industrial manufacturing, agriculture, finance, mobility, the Green Deal, and the public administration, and so forth. The Commission is introducing, in that regard, common interoperability standards and sectoral data governance rules, for example, model contracts, licenses, and access rights, alongside also ensuring that the EU budget is funding the development of the actual common IT infrastructure for these data spaces. These data spaces are believed to have the potential for maintaining balance between the need to protect intellectual property rights, personal data, and competition law, while also promoting data sharing in both B2B contexts and with public sector bodies. They also provide a platform and shall be able to provide a platform to address the inconsistencies and lack of communication among existing EU Pro data sharing regulations, as we mentioned earlier. The overarching goal is to thus create an environment where market participants feel empowered to share more data for economic and societal use while retaining control over the data generated by them. Stay tuned for our deliverable. Antonis, please, the next slide. Yes, our deliverable 4.6, I think it shall be due officially, publicly, by the end of the year. It is going to delve into all these aspects in very robust details, providing practical guidelines within the meaning of the DATAMITE pilots, which we have listed here, which deal with different topics. So what you're going to get from this deliverable is, on one hand, the very comprehensive and detailed framework with offered codes of conducts and good practices, so a very practical attitude, and then also the context of the experience within the DATAMITE pilots. And of course, should you wish, we can also prepare part 2 of this webinar once you have gone through the deliverable itself as well, because as you see, it's a robust framework. And then we can make one more webinar addressing any any questions you are searching answers for. Thank you so much for your attention. Yes, stay compliant, and we are here to help you to achieve these and maintain the effective data sharing within the EU.
Mm-hmm.
Thank you.
Thank you very much, Polina. Thank you very much, Margit, for your contributions and the excellent presentation you have offered us. I know that it will follow a part 2 for Q&A and more information about the legal frameworks and so on. But if there is a question now, if someone wants to... Yeah.
Yes, I'm sorry, could you please go to the next slide? There is one more. Of course,
Okay.
you can always, of course, you... no, the other, of course, you have the sources, but then the last one, the next one, yes, of course, you can also reach out, because obviously time is not sufficient. You can reach out with more detailed questions you may have.
Perfect.
This is in addition to the offered second part.
Excellent. So
Yes.
if there is any question, you can raise your hand at the bottom of your screen, and then we will try to accommodate that. I know the time is way beyond, let's say, 5 minutes, but if there is a question that needs to be answered now, please let us know, and we will.
And otherwise, certainly feel welcome. Even 1 month, maybe you have this very interesting afterthought of the webinar. Do not worry, even if it is around Christmas, you're more than welcome to email us. And we're going to very carefully address your question.
Excellent. I don't see any questions, so I would say that we keep it as is. Now, the webinar will be uploaded in our repositories, in our video repositories, and will be shared through our social media and the website. So for the colleagues who could not join today and, let's say, attend to this interesting webinar organized by DATAMITE and LEAF, you are welcome to share the link or to share the information where you will find the information. Thanks to all, and enjoy. Bye.
Thank you. All the best. Bye.